social media. So to that extent, that is beyond the control of this body as to what people may put on Facebook on their own time or other social media.
And there was another statement that I believe was made just a few moments ago, and it was about a discussion on something that the commission prior to this commission made regarding monuments. I think this commission had a comment made, and I thought it was brought to us for the purpose of making another decision, but I don't know how fully that panned out. But did you want to make comments regarding that as well?
Regarding the monument?
Yes.
Okay. Well, at the last meeting where that topic came up, I was at a loss for not knowing what the history of the litigation was. But I have since done some research and have discovered that back in 2021, the City Commission passed a resolution authorizing the city attorney to prepare a letter for the mayor to sign. The letter was directed to the Sons of Confederate Veterans, asking them to remove the monument from Phoenix Park. That letter apparently was sent, and as a result of that, the Sons of Confederate Veterans filed a petition for an injunction against the City of Waycross, asking the court to enjoin the city from forcing removal of that monument. That petition was responded to by the City of Waycross, along with a motion to dismiss the petition. That was a hearing in court, and the court decided that the petition would be dismissed because the resolution that was passed by the city provided that in the event the Sons of Confederate Veterans did not remove the monument, the city would consider a future resolution for litigation regarding the removal. So in that sense, there was no immediate threat to the Sons of Confederate Veterans, which is what you have to demonstrate if you file a petition for an injunction. You have to show that there's immediate harm or something is about to happen, and the extraordinary powers of the court are necessary to prevent that something from happening. But the judge looked at the resolution and said, well, the resolution said that there would be a future resolution or future consideration for litigation by the city in the event that initial letter was not adhered to. So in that sense, it was speculative. There was no immediate threat to the organization. So the court did, in fact, dismiss that petition for an injunction. Now, there has been some theory that the city at some point in the past accepted the monument as a gift. There's no record of that as I'm aware of. I also received a phone call after that last meeting from an attorney up in Marietta, Georgia, from a Mr. Martin O'Toole. He called me on April 17th and said to me that the theory of the argument made by the Sons of Confederate Veterans was that the city owns the monument by adverse possession. And I'm not really sure that adverse possession applies here. Adverse possession is a real property concept that says if you take possession of someone else's property for a continuous period of 20 years, openly, notoriously, and against the will of the true owner, then at the end of that 20 years, you can actually go to court and have the court declare that you now own it. A more classic situation would be if you have a fence that you put up on your neighbor's property, and you take, say, 10 foot of your neighbor's property, and you put up a fence, and you mow the grass and plant a garden, or you do whatever to indicate that you own that additional 10 feet, and you do that for a continuous period of 20 years, and you're not made to take your fence down, you can own that property by adverse possession. But it requires some affirmative act on your part to have a court declare that you own it by adverse possession, and it has to be against the true will of the will of the true owner. Applying that to the context of these Confederate monuments, I don't know how that would operate in this case, because I don't think the city ever said we claimed that we owned this 20 years ago, and 20 years later now it's our property. I don't think that happened, nor was there any gift of the property that was accepted by the city. And I think Mr. O'Toole was going to send an open records request to have the clerk search the minutes from 2021 going forward to see if there was any resolution or minutes that would address whether or not the city was accepting the monuments as a gift. And the clerk informs me today that she has not received that open records request. And I seriously doubt that there is anything like that in the city's records. And the reason why all of this is important is because in 2019, the Monument Protection Act was passed in Georgia, which said that public monuments on public property cannot be moved. Private monuments on private property cannot be moved. But the Monument Protection Act does not protect private monuments on public property. And in order to have the city in a position of having to be forced to not to be able to remove that monument, the plaintiffs would have to show that this monument is no longer a private monument, but that it is a public monument because the city received it as a gift, or the city adversely possessed it under the 20-year adverse possession statute. So in the absence of that kind of evidence, it remains a private monument on public property, which is a category that is not covered by the Monument Protection Act. So at this juncture, the city would have to decide whether you want to adopt another resolution that would actually authorize litigation to move it, because that would be the next step based upon the resolution that was passed in 2021.
Very good.
So we're back to square one.
And that's what I was understanding of. You basically talk about like the law of acquiescence, where someone walks back and forth on your property and you never stop them, so they make a pathway there. And then once that path has been made after a period of time, you can't say that it's private property anymore. Now it becomes public domain, if I'm not mistaken. So I'm concerned that when we have this conversation, that the commission that sits with me now was not the commission, and not one of the persons sitting with me now was here when that resolution was written and or voted on. And the day that I went into the court, that was not about him dismissing the resolution. It was him dismissing the injunction that was set against the city of Waycross.
Yes.
Because the goal there was to make us keep or leave them alone, basically, is what the statement was. And I do understand from that day forward, there has not been any more conversation until just most recently. And then as that conversation came up, this commission was made aware of the last meeting that we had regarding the canon and the monument. Okay. So I hope there's clarity for Mr. Peacock, because we want to make sure he understands that decorum only deals with our meeting. It has nothing to do with, we can't tell a person that they don't have a First Amendment right when one person says something against another person or against something that maybe they want to respond to. They can respond. That's their First Amendment right. They can work here and still be respondents. So I don't think, and you can, if you want to speak to that as well, Mr. Attorney.
About the First Amendment right?
Right. If they want to respond on a social media platform or any other thing of that sort, are they limited because they're here?
No. a person does not lose his or her First Amendment right because of their employment. The First Amendment guarantees every citizen the right to express themselves, whether it's on social media or in person or by letter. That right cannot be infringed upon by any other person.
And Ms. Mayor, if I can, our social media policy is they cannot speak on bad on the city. So, and we don't have a daytime policy. I encourage our workforce to be on social media to respond to citizens' wants and needs and requirements. I'm on there pretty much the whole day responding to information. So we don't have a daytime policy that might be similar to like a school or something of that nature. So make that clear as well, because that's part of the argument as well.
Okay. And that was a statement I was asking regarding, because I do want to know or make note to community persons if they write things and other people respond to it, is they're not bound to hold their hands in their laps and read. Correct. And just let it be. They can respond however they choose. And the other piece there that was stated by Mr. Peacock was something about campaigning. Campaigning has not, well, campaigning can begin, but qualifying has not. Therefore, that does not fall within the scope of candidacy, does it?
No, qualifying doesn't start until the third week in August for the upcoming election. So no one is a candidate at this juncture. Someone may announce early that they intend to be a candidate, which is fine, but no one is a candidate until they qualify.
Okay. And that clears up a few things that were just previously stated. And the reason we wanted to make sure that's clear, so no one will feel that someone's being taken advantage of. Madam Clerk, we have one more?
Yes, her name is Crystal Scott. Ms. Scott, if you'll come and take the podium, please state your name and address for the record. She is here to speak on inspections.
Inspections, okay.